Hello everyone, welcome to another episode of CCP Digest. Your host today is Navagala Denise Ashley, and my colleagues are going to introduce themselves.
Hello, digesters. My name is Matenga Davin, and I'm very happy to be here today.
Hello, digesters. My name is Jesse Etanu, and I'm excited to be with you today.
Yes, so let's dive right into it. Today we're looking at a recent court decision, and one of my colleagues is going to take you through a nutshell of the facts of this case.
So the case we are looking at here is Simba Properties versus Vantage Mezzanine Fund. The facts are that in 2014, Simba Properties Ltd took a loan from Vantage Mezzanine Fund worth $10 million US. And we see that this case actually went to court, reason being that Simba Properties Ltd had actually defaulted on its loan payment. Yeah.
Thank you so much. So now that we have a little overview of what the case is about, it also brought in some kinds of inquiries regarding arbitration, international business. So what's the major basic explanation of arbitration? What can you tell us about it?
Thank you so much, Sheila. So understanding arbitration is simple. Arbitration is a form of dispute resolution where two parties in a dispute present their dispute to a neutral third party to get a binding resolution on that matter.
Thank you so much. So now, how is arbitration related to what we are handling today?
Yeah, thank you very much. So looking at what we are handling today, we see that one of the reasons why these people went to court was because there was a default in payment of the loan. Now, looking at the loan agreement, we see that there was a provision for arbitration, whereby in case one of the parties breached the agreement, they would resolve the issue. See that they decided to go to court, and the court referred them to go for arbitration at the International Chamber of Commerce. So when they went for arbitration, they ruled in the favor of Vantage Mezzanine Fund. So on coming back to Uganda, they had to come back to Uganda to enforce the award that was granted by the International Chamber of Commerce. So now that's where we see the kind of chaos happening. Yeah.
Thank you so much. So let's put a pin into that. We're going to get back to the arbitration clause. Now, what is the structure, the mezzanine Vantage Fund structure? What is it exactly about? What is its facility agreement? We'd like to get to know about that.
Thank you so much. So to understand this agreement, first need to understand one of the parties, that is the Vantage Mezzanine Fund. This was a foreign partnership that was not registered in Uganda. This partnership was based in South Africa, and it's the one that extended the loan to Simba Properties. Then, what is this mezzanine loan facility that was extended to Simba Group of Companies? We need to know that a mezzanine loan facility is basically a debt agreement or a loan agreement in which the debt that is owed to the lender can be transformed into shares in the company that borrowed money from the lender in case there is a default in payment. And we see that this is the kind of agreement that was entered into between Simba and Vantage.
Thank you so much. So now, what are the legal challenges or any challenges that came across in all of this, in the structure, in the way that they were processing their kind of case? What are the challenges that they were facing?
Okay, looking at some of the legal challenges that they faced, one, we saw that Simba Properties raised an argument of Vantage not being registered in Uganda under the Business Names and Registration Act and also under the Partnership Act. And because they were not registered, therefore they could not bring a claim in Uganda and claim that they were entitled to some of the securities that were under Simba Properties. You get? Yeah, so those were some of the legal challenges that they were experiencing.
Yes, thank you. Now, I think the audience is asking itself the question I'm asking myself right now. Can a foreign partnership or company conducting its business in Uganda, can it initiate its legal contractual proceedings? Can it come about and be like, oh, I have a case, but I'm not registered here? Can it do that? And how is that related?
Okay, very good question. So looking at the ruling that came out in the Court of Appeal, the Court of Appeal was very clear, and they stated that a foreign lender that lends money to any Ugandan business or investor can bring a claim to recover its money. You get? And they also went on to interpret that provision in the Partnership Act, which provides for a business to register within Uganda. And they said that for a business to be registered in Uganda, it must be working and operating within Uganda. So meaning it must be already in place, it must have operations in place in Uganda for it to be registered. Yes, so that's where that section particularly applies to. But in this case, it did not apply to Vantage Mezzanine Fund, because we say that Vantage Mezzanine Fund was simply just a lender, a foreign lender. It just lent money, but it didn't have any operations within Uganda.
Thank you so much. Now, what about the foreign investors who are one-offs, who are dealing with one-offs? What of their position in this kind of scenario?
So the foreign investors.
Foreign investors, actually, it's a good thing, because we see that this ruling has actually restored investor confidence. So we see that foreign investors are heavily protected with such a ruling. They know that they will lend money to in Uganda, and they know that they can recover that money. Look at the similar instance that happened in the case of Ham versus DTB. This was the same scenario whereby Ham took a loan from DTB Kenya, and he tried to play tricks claiming that DTB Kenya was not registered in Uganda. And they held against him that actually DTB Kenya could actually raise a claim and recover its money from him. Yeah.
Yes, thank you. So now back to the point I had mentioned of the arbitration clause. What does it exactly imply? What did it bring about? What are its major components?
Thank you so much. So, when it comes to the arbitration clause, it stated that in case or in the event that there was a disagreement to do with the loan agreement, any kind of dispute that would arise in that contractual relationship, these parties would go into arbitration. Yeah, what I had described, where a third party, that would be the International Chamber of Commerce, would come in to settle the dispute between the two conflicting parties. And that was the clause that referred them now to London to settle the dispute that they had.
Now, thank you so much for that. Now we also have Uganda seems to have an arbitration act. Can I say the Arbitration and Conciliation Act?
Yeah.
And then does it exactly speak about the post arbitral award that we looked at this case? Because there was my research, there was a post arbitral award that was given to Vantage. Yes. So now what about that?
Yeah, very good question. So looking at the laws of Uganda, looking at the Arbitration and Conciliation Act, we find that the laws do not provide for post-award measures, you get? However, the laws only provide for measures whereby the arbitration is ongoing. There are some measures that can be applied to actually maintain the status quo. But award has been by the ICC, there is no post-award measure there. So we find that there is a loophole in our legal system there, which actually affects mainly the party that is actually victimized. For instance, we see here in this case, we see that when they were granted that, when Vantage was granted that award from the arbitration, from the arbitration, they came to Uganda and they applied to court, and they were like, they wanted that post-award measure. Reason they feared that actually Simba Properties would tamper with the securities and the shares where they had an interest in. Yes.
Thank you so much. Now, were there any challenges to this post-arbitral award? Was there anything that the other party was trying to do to contrast with the Vantage people?
Yes, very good question. We see that in that period whereby they were waiting for the award to be granted, we see that one, Simba Properties tried to tamper with shares in its different companies. It also went ahead to contact URSB on not granting Vantage access to those shares simply because they claimed that Vantage was not a registered company within Uganda. Therefore, it could not have access to those shares.
So those were just some of the
tricks that Simba Properties tried to use to actually delay the award from being granted to Vantage. Yeah.
Thank you so much. Now, what does this Simba case, what's its impact in other East African jurisdictions who are developing their framework concerning arbitration? What do you think the case has really brought to light?
Thank you. This case is very impactful, both in the financial and in the legal sense. We need to understand what the Court of Appeal judgment was in order for us to be able to get a full picture of it. We know that the Court of Appeal, in giving its final decision, said that even if Simba as a company or as a partnership, sorry, was not registered in Uganda, it could still enforce the contract that it had between it and Simba Properties. And this is something that is so crucial to Uganda's economic and financial system, because it gives investors, especially foreign investors, confidence in lending monies to Ugandan entities, because they now have an assurance from the judicial system that they can get justice in events such as this, where there's a default in payment. And in the legal sense, we know that it's something that is profound, because we know that the judges in this case called out to the legislature to go ahead and make
law
to the arbitration
consideration on what
on being able to give people or different entities post-arbitral measures of protection, you know, because in our current act, there are no, it's not provided for that the courts can give protection to arbitral awards after.
this
So that's how it is significant in both the financial and the legal sense.
Thank you so much. So what you're implying is that
Yes.
there has been a legislature gap between our laws and
Yeah.
arbitration in general. Is that what you're trying to bring out here?
There's been a legislative gap there. When you look at Section 6 of that act, the Arbitration and Conciliation Act, the courts have only uh, a limited space to be able to give protection to entities that are in the process of arbitration before and during the process of arbitration. But the Act explicitly does not mention that the court can give protection after the arbitral award has been given. And this is something that was capitalized on by Simba when the court went to court, sorry, when the case went to court, because the council said that the act does not provide for the kind of uh, statutory protections that Vantage was seeking for.
Exactly. Thank you
Yes.
so much. So now that the case really brought that aspect to our understanding, what's its bottom line impact for Uganda as a country? What do you think it has actually addressed? What is it bringing out here?
So, looking at this case for Uganda, first of all, one, it's an eye opener because it has opened our eyes to the loopholes within the laws, the Arbitration and Conciliation Act, and it has also woken up the judiciary and the legislature to come together and see how they can bridge that gap. Then, secondly, if that is done, if they are to put in the legislation in place, I believe it will help Uganda as a country and the economy at large. Because you find that if Uganda is able to fix that and we become an arbitration hub, that adds on to our economy. Because you will find that very many multinational companies would choose Uganda because of its favorable arbitration laws, and they will come here and arbitrate here. But remember, as they come here, they're also bringing in foreign exchange,
so
the economy in one way or the other. Yeah.
Thank you so much. Now, what takeaways can you give to our audience? What can we literally take away from our fingertips from what we've discussed today?
I guess the biggest takeaway for me is on arbitration and the importance of it. The courts in this case of Simba and Vantage, they stress the importance of arbitration and how courts will always push to protect the integrity of arbitration. And we see it in this case because even though the Act did not explicitly have protections for post-arbitration, in the case of an arbitral award, the court still went on to interpret the law in a flexible way in order to accommodate the act of arbitration because it reflects international best practices in dispute resolution.
Yes. And what about you?
Looking at that, my take would be actually I would be passing on advice to businesses and companies that wish to uh, indulge in arbitration and include it in their contracts and all that, that they must be careful how they include those arbitration clauses. Normally, you need to do a background check on the country that you would wish to do the arbitration from. And again, also become a bit friendly with their laws, right? You know what their laws are and if they favor you in case you want to do an arbitration there.
Yes, thank you so much. My personal conviction from all this is that instead of going through the tedious processes of court, we can opt for other alternative dispute resolutions, like what we discussed today, arbitration. Then I think there is mediation or something of that sort. So I think that has really covered what we're supposed to discuss today. Thank you so much. Thank you to our audience for giving us a chance to explain to you concerning this commercial dispute. Thank you for tuning in, and please enjoy your day and have a wonderful time.